Now we're going to go back and be a real academic conference, okay? The three members of our first panel, in the order in which they will present, are first of all, Laura Kessler. She is a professor of law here at the University of Utah. Laura is a nationally known expert in family law, known for her work on non-nuclear families and work-family conflicts. Today, she's going to give us the background on Stump v. Sparkman. Although the case stands for the proposition of judicial immunity, Laura is going to explore the relevance for family and social welfare law. And at this point, I want to give my special thanks to Laura, because without her enthusiasm for and commitment to this project, we would not be here today.
Okay. Well, so I'm Laura Kessler, and I'm so delighted to be here, and I also want to express my mutual appreciation to Deborah. Deborah wrote this play a few years ago and asked me to write a short commentary placing the play in context and giving a little more background, and I have become so obsessed with this case that I now have a 60-page law review article, and I'm still not finished. I also want to say that I've heard the play read 3 times, and I'm still moved every time. I think this is such an amazing play, and I really do hope it will be produced so it can be shared with a wider audience. Okay, so I have been asked as part of the symposium to just give some background about the actual Supreme Court case which inspired the play, which was called Stump versus Sparkman. It was decided in 1978. So what I'm going to do is start with the background in terms of the facts, the procedural history, and the court's holding. And then I guess I have a larger aim, and I don't think I can do it in 15 minutes, but I'm going to try to start, and I guess Professor Lombardo will finish, but to contextualize this case within the sort of longer trajectory or history of eugenics and sterilization abuse in the United States. Okay, so on July 9th, 1971, Ora Spittler McFarland of Auburn, Indiana, through her attorney, Warren G. Sunday, presented a petition to Judge Harold D. Stump of the DeKalb County Circuit Court, asking to have her 15-year-old daughter, Linda Spittler, surgically sterilized. As you heard from the play, some of which is actually factually true, she alleged that her daughter was somewhat retarded and was associating with older youth and young men, and that it would be in her daughter's best interest to undergo a tubal ligation to, quote, prevent unfortunate circumstances. This sterilization petition was a very unusual legal document. It had no caption naming the parties to the case or the court. The caption merely read, State of Indiana, County of DeKalb. The order for the judge to sign was typed at the bottom of the petition, and interestingly, it contained an indemnification clause holding the physician who was to perform the sterilization harmless from any causes of action that might result from the tubal ligation. This is odd, right, to have an indemnification clause attached to an order that's a request for a judge's order for the sterilization. It's not really clear, but I think it's fair to say that this indemnification provision suggests that the physicians that may have been actually involved in her decision to seek her daughter's sterilization, or at least that the parties had some doubt as to whether the operation was even legal. Judge Stump signed the requested order the very same day he received the petition, without notice to the child, without a hearing or receipt of any evidence, without appointment of a guardian ad litem to represent the child, without citing any legal authority for the action being taken, without even docketing the case, and indeed, apparently without ever seeing Linda. Interestingly, Linda Spittler, who's changed her name, she asserted in her memoir that Judge Stump approved the petition, quote, while standing on a street corner talking it over with her mother. Now, this fact is not included in the Supreme Court opinion, but Justice Stewart's dissent actually seems to corroborate this account. Justice Stewart noted that Judge Stump acted with informality and may not have been in his judge's robes or even the courtroom itself. 1 week later, Linda Spittler entered DeKalb Memorial Hospital just 4 blocks from her home. She was told that she was going to have her appendix removed, and the next day a tubal ligation was performed on her by Dr. John H. Hines, assisted by another doctor and an anesthesiologist. So 2 years later, Linda Spittler married Leo Sparkman. Failing to become pregnant, she learned from Dr. Hines that she had been sterilized. At first, he denied it, but I believe her attorney She hired an attorney and asked for the records, and then he finally admitted that he had performed this procedure. The Sparkmans, as a couple, actually, both of them were plaintiffs, brought a Section 1983 federal civil rights claim for damages against Linda's mother, her attorney, Judge Stump, and the doctors who performed the operation, as well as the hospital. Now here, I think it's important to provide a brief primer on civil rights law. Section 1983 makes relief in the form of money damages available to those whose constitutional rights have been violated by any person acting under color of state law. So clearly, Judge Stump's employment by the government indicated state actions. There's really no issue with that. The private parties, on the other hand, were sued under a conspiracy theory. According to Sparkman's complaint, the private parties and Judge Stump acted, quote, in concert and with the common goal and result of sterilizing her because of her marital status and her allegedly low mental ability and her sex, depriving Sparkman of her constitutional rights to privacy, due process, and equal protection. The trial court dismissed this lawsuit as to all of the parties on the ground that Judge Stump, the only state official named as a defendant, was absolutely immune from suit, and consequently no state action could be shown, which was necessary to all of the federal civil rights claims. So once Judge Stump is gone from this litigation, the state action evaporates, and so therefore there's not a state action with regard to the private parties, at least for a civil rights claim. Okay, so the Sparkmans appealed to the Seventh Circuit Federal Court of Appeals, which reversed. The appeals court held that immunity is not available when a judge acts in, quote, clear absence of all jurisdiction. Although Indiana law at this time permitted the sterilization of institutionalized persons under certain circumstances, it provided for a notice, an opportunity to defend, and a right to appeal. The court found no basis in statutory or common law for a court to order the sterilization of a minor child simply upon a parent's petition without any of these procedural safeguards, and moreover, she was not institutionalized. So there was no statute or even common law authority for the judge on which to base his order. Okay, so now this gets to the Supreme Court. Judge Stump and his co-defendants appealed to the United States Supreme Court, which granted cert and reversed the Court of Appeals. Justice White, writing for a 5-member majority, disagreed with the determination by the Court of Appeals that there was a clear absence of all jurisdiction for Judge Stump to consider Ora McFarland's petition. Justice White noted that Indiana law gave circuit courts original exclusive jurisdiction in all cases at law and in equity. So the argument or the conclusion by the majority of the justices was that there was general jurisdiction, right, to hear any type of dispute, and so he could have heard this. The Supreme Court also found that Judge Stump's order was a judicial act, a second requirement for judicial immunity. A judicial act, according to the court, exists where the judge's act is one normally performed by a judge and where the parties dealt with the judge in his judicial capacity. In the view of the majority, Judge Stump's action passed this test. So Justice Stewart wrote, as also referenced in the play, wrote a stinging dissent, and he said, what Judge Stump did was beyond the pale of anything that could sensibly be called a judicial act. There is no reason to believe that such an act has ever been performed by any other Indiana judge, either before or since. Justice Stewart, his ire, his anger was also apparent during oral arguments. If you listen to the oral arguments, this is what he asked the attorney for Judge Stump. What if Mrs. McFarland had presented a piece of paper to your client, the judge, my client, the judge? Excuse me, what if Ora McFarland had presented a piece of paper to your client, the judge, and said, my daughter is a kleptomaniac. She's done a lot of shoplifting, and I want your approval to have her right hand chopped off. And the judge had signed the approval, and the surgery had been performed. This is what Justice Stewart asked the attorney for Judge Stump. If Stump were to approve such an application, would you be making the same argument? Stewart asked. The attorney for Judge Stump replied, an amputation would be inappropriate because cutting off her hands is not going to improve her physically. Yeah. Amazing, right? Okay, so according to the Washington Post, when the Supreme Court issued its ruling on March 28, 1978, Justice Stewart read aloud most of his 5-page dissent from the bench, which was an infrequent occurrence for dissenters. According to this news article, Berger's face reddened, the justice sitting next to him, and the other justices also appeared very uncomfortable. Quote, "The tension struck observers as almost palpable." Now, there's some additional procedural history from this case. I don't think I have a lot of time to go into it, but after the Supreme Court issued its decision, Judge Stump was off the hook. But there was a question that was left undecided, and that was, must Linda Sparkman's federal civil rights claims against the private parties be dismissed now that Judge Stump, the only state official named as a defendant, was found to be absolutely immune from suit? The Supreme Court remanded this issue, known as derivative immunity, back to the Seventh Circuit Court of Appeals. Again, I won't go into detail, but the short story is that the Seventh Circuit, on its second pass, dismissed Linda Sparkman's lawsuit as to all of the defendants. Shortly after the Supreme Court issued its opinion, Judge Stump was reelected to another 6-year term. So what's this case about? Legal scholars have principally regarded Stump versus Sparkman as a remedies case. It stands for the proposition that judges are absolutely immune from suit for their official judicial acts. I do want to talk for a minute about this doctrine or this idea, because I think when I first wrote this paper, it got lost, and I was just so wrapped up in the injustice of it all that I do think it's important to talk just for a second about this idea of judicial immunity. The policy goal underlying judicial immunity is important, right? And it shouldn't be lost in a discussion of this case. In the normal course, a party who believes he's been wronged by a judge acting in his official capacity can ask the judge to reconsider, appeal to a higher court, or if the party suspects judicial wrongdoing, file a complaint with the Bar Association. However, generally, a party cannot sue a judge for in his personal capacity, right, for monetary damages. That is, there's a widely accepted principle that judges should not have to answer to a lawsuit whenever she issues a ruling that makes a litigant unhappy. So one way of understanding this case is that it's just about judicial independence. And the place of Stump in this larger history, if you read, what books does this appear in? It's generally remedies case books or civil rights. And this is the basic, if you want to say Stump versus Sparkman, typically people say, oh, that's the judicial immunity case, right? But what I want to do I guess I only have 5 minutes, and I'll try to shorten what I was going to say, but it's to sort of place this case to recontextualize it, right? To place it in this larger history of eugenics in the United States. And that is less discussed, I think, when in the scholarly treatment of this case. So basically, the basic scenario, and this is, I think, for our expert speakers is well known, but maybe perhaps to others in the audience, so I do think it's worth discussing for a minute. I mean, the basic scenario presented in Linda Spitman's case, her action, that was not an aberration. Beginning in the 60s, the medical profession and the government systematically targeted African American women and poor women for family planning services as part of an anti-poverty and population control agenda. And it was a period when forced sterilization moved from the realm of eugenics boards and mental institutions to federal family planning. For example, the government increased expenditures for birth control between 67 and 71 from $4.5 million to $24 million for the explicit purpose of diminishing poverty and reducing welfare dependency. In 1974, the Federal Department of Health, Education, and Welfare decided to develop an attractive funding scheme for states to reimburse states for sterilizing poor women. And between 74 and 87, the ACLU Reproductive Freedom Project brought 21 forced sterilization lawsuits. One of the most significant ones was Ralph versus Weinberger. This one was actually filed by the Southern Poverty Law Center in 1973, which was before this case was decided by the Supreme Court. In Ralph, 2 African-American girls in Montgomery, Alabama, Minnie Lee, age 14, and Mary Alice, 12, were sterilized without their mother's knowledge or consent. And the Southern Poverty Law Center brought a suit on their behalf. And I guess the reason I'm talking about this case is what's interesting about it is the findings of the court. And the court found that, and this is a factual finding, that over the past few years, an estimated 100,000 to 150,000 low-income persons have been sterilized annually under federally funded programs. The court also found that there was uncontroverted evidence in the record that minors and other incompetents have been sterilized with federal funds, and that an indefinite number of poor people have been improperly coerced into accepting sterilization operations under the threat of losing their federal welfare benefits. So I guess I'm just going to move ahead here, but what I try to do with the paper is to connect this case, Stump versus Sparkman, and to place it in this, first of all, to place it in this context, right, of this period when there was a lot of sterilization abuse, particularly of poor women and women of color, occurring. And secondly, to actually even go further than that, to place this case in the long arc of eugenics in the United States, going back all the way to Buck versus Bell, and then moving forward into the current time. And where I end is to sort of puzzle through whether there are things happening now today that we could call eugenics, or we could say that share certain continuities, you might say, with our eugenic past, the history of eugenics in the US. And I'm just going to take off a few examples. In the 80s, there was a trend of prosecuting drug-addicted women who delivered drug-exposed babies for a variety of crimes, including criminal neglect, delivery of drugs to a minor, and involuntary manslaughter. Many of these women, their children were removed from them, or they were put in prison. There were welfare reforms in the 90s, such as the family cap, which prohibit families on welfare from receiving an increase in their benefits if they have additional children. And there are some interesting studies today showing African American women and women with no public insurance are about 50% more likely to have undergone tubal sterilization compared with white women and women with private insurance. And then there's some other areas I'm looking at. There's some recent cases where deadbeat dads, quote unquote, who fail to pay child support are, as a condition of parole, they're prosecuted for criminal non-support, are told that you have to have a vasectomy as a condition to parole. And then even more recently, if you are moving, sort of further out in terms of my thinking, I'm working on an issue with regard to marriage equality, and a lot of the rhetoric and justification for not allowing same-sex couples to marry is about their unfitness, essentially, to be parents. So I think it's fair to say that Stump versus Sparkman is a lot more than, it's not just a remedies case, it's not just about judicial independence, it is all about all that, but it also demonstrates how the long shadow of eugenics in the United States extended well into the 20th century, and arguably, for discussion, I guess, we can discuss that, continues today. Thank you.